The certified letter sitting on my kitchen counter might as well have been a bomb with a lit fuse, because that's exactly how it felt when I opened it and read that my house was about to be foreclosed on by the Meadowbrook Estates Homeowners Association. I'm Trevor Fitzgerald, a software engineer who'd been living in this quiet subdivision in Raleigh, North Carolina for the past 3 years. And until that moment, I thought I'd been doing everything right. The letter claimed I owed over $2,000 in unpaid HOA fees and that a lien had already been placed on my property. The kicker: this was the first I'd heard about any of it. No warnings, no previous letters, no phone calls, just straight to threatening foreclosure. My hands were shaking as I read through the legal jargon, my coffee getting cold beside me. I grabbed my phone and pulled up my bank statements, scrolling through months of automatic payments. Every single one had gone through. $65 a month, like clockwork, deducted on the first of every month for the past 3 years. I'd never missed a payment, never been late, never had insufficient funds. The evidence was right there in black and white. My first instinct was to call the HOA management company listed on the letterhead. After being on hold for 20 minutes listening to the worst elevator music known to mankind, a bored-sounding woman finally picked up. Meadowbrook Estates, HOA. This is Patricia speaking. Hi, I just received a letter saying you're threatening to foreclose on my house for unpaid dues, but I have bank statements showing I've paid everything on time. There must be some mistake. Name and address, she asked, not sounding particularly concerned about my panic. I gave her my information and heard the clicking of keyboard keys. The pause that followed stretched out uncomfortably long. According to our records, you haven't paid your dues in 18 months. That's impossible. I have proof of every payment. Well, our system shows otherwise. The lien process has already started. You'll need to pay the full amount plus late fees and legal costs, or we'll proceed with foreclosure. My jaw clenched. I want to speak with whoever's in charge of the HOA board. That would be Mrs. Brenda Carmichael, the HOA president. She's not available right now, but I can have her call you back. When? Within 3 to 5 business days. I hung up before I said something I'd regret. 3 to 5 business days. They were threatening to take my house and couldn't be bothered to call me back for almost a week. This was insane. I spent the rest of that Tuesday afternoon gathering documentation. I printed out every single bank statement showing the HOA payment, highlighted each transaction, and organized them chronologically in a folder. I also pulled up my original HOA agreement from when I'd purchased the house, reading through it more carefully than I had in years. That's when something caught my eye. There was a section about notification requirements for liens and collection actions. According to the governing documents, the HOA was required to provide written notice at least 30 days before initiating a lien, and that notice had to include an itemized statement of charges and an opportunity to request a hearing. I'd received none of that. Zero. Zilch. Nothing. My phone buzzed. It was my neighbor, Gary Henderson, asking if I wanted to grab a beer after work. Gary was a good guy, a high school teacher who'd lived in the neighborhood for about 5 years. I told him I couldn't, that I was dealing with some HOA drama, and his response was immediate. Dude, is this about those lien letters? I got one too. So did the Johnsons and the Martinez. Brenda's on some kind of warpath. That stopped me cold. Wait, this is happening to other people? Yeah, like 6 or 7 families that I know of. Everyone's freaking out. We're supposed to have some kind of emergency meeting Thursday night at the clubhouse. I told Gary I'd be there, then sat back in my chair, my mind racing. This wasn't just incompetence or a clerical error. This was systematic. Brenda Carmichael was either completely negligent or deliberately targeting homeowners. I needed a lawyer. The next morning, I took a half-day off work and drove to the office of Sarah Mitchell, a real estate attorney whose name I'd found through a quick internet search. Her reviews mentioned she'd handled HOA disputes before, which was exactly what I needed. Sarah was in her mid-40s, professional but approachable, with reading glasses perched on her nose as she reviewed my documentation spread across her conference table. "This is pretty clear-cut," she said after about 10 minutes of reading. "You've been making payments. Do you have any idea where they're going? That's the thing. The money's been leaving my account, so someone's been receiving it." She nodded slowly, making notes on a legal pad. North Carolina has very specific statutes governing HOA collections. They're required to follow strict notification procedures before placing a lien on your property. From what you're showing me, they didn't follow any of them. "So what can I do?" Sarah leaned back in her chair. "You can sue them. North Carolina General Statute 47F has provisions for wrongful lien filings. If an HOA places a lien without proper notice and due process, they can be held liable for actual damages, attorney's fees, and statutory damages. The statutory damages alone can be significant." My heart started beating faster. How significant? Potentially thousands of dollars, depending on the circumstances and the judge's discretion. Plus, if we can prove they acted in bad faith or with gross negligence, it gets even better for you. I hired her on the spot. The emergency HOA meeting Thursday night was exactly as chaotic as I'd expected. The clubhouse was packed with angry homeowners, everyone talking over each other, waving letters and printouts. I spotted Gary in the crowd and made my way over to him. "This is crazy," he muttered. "Half the neighborhood is here." At the front of the room, Brenda Carmichael stood behind a folding table with a microphone. She was exactly what I'd expected. A woman in her late 50s with a severe haircut and an expression that suggested everyone in the room was personally inconveniencing her. Flanking her were two other board members, both looking distinctly uncomfortable. "If everyone could please settle down," Brenda's voice crackled through the cheap sound system. "We're here to address concerns about recent collection notices." "You mean the foreclosure threats?" Someone shouted from the back. Brenda's lips thinned. "The association has a responsibility to collect dues. Many homeowners have been delinquent in their payments." I raised my hand, but didn't wait to be called on. "I've made every single payment for 3 years. I have bank statements proving it." "Where's that money going?" A murmur of agreement rippled through the crowd. Several other people started shouting similar statements. Brenda held up her hand. "There have been some accounting discrepancies that we're working to resolve. However, according to our official records, which are maintained by our management company, these dues remain unpaid." "So you sent Lien notices without verifying your records were accurate?" This came from a woman I didn't recognize, holding a thick folder similar to mine. "We followed proper procedures." "Did you send the required 30-day notice?" I pressed, because I got nothing until the Lien letter showed up. Brenda's expression hardened. "These matters should be handled individually, not in a public forum. If you have specific complaints, you can schedule a hearing." "We're requesting hearings right now," Gary said. "All of us. We all want hearings." The meeting devolved further from there. Brenda tried to maintain control, but it was clear she'd lost the room. People were furious, and rightfully so. The idea that the HOA could just threaten to take people's homes without proper documentation or notice was outrageous. As the meeting broke up, I noticed several people approaching Brenda with their documentation. She barely glanced at what they were showing her, dismissing each person with a wave of her hand and a promise to look into it. I didn't bother joining that line. I already had a lawyer. The following Monday, Sarah filed a lawsuit against Meadowbrook Estates HOA, Brenda Carmichael individually, and the management company they'd hired. The complaint was thorough, detailing every violation of North Carolina HOA law, the lack of proper notice, the wrongful lien filing, and demanding removal of the lien, actual damages, attorney's fees, and statutory damages. The response came faster than I'd expected. 2 days after we filed, Sarah got a call from an attorney representing the HOA, requesting a meeting to discuss settlement options. "They're scared," Sarah told me over the phone. "They know they screwed up and they're trying to make it go away before it gets worse. I don't want to settle. I want them to answer for what they did." "I understand, but let's at least hear what they have to say. It might be worth it, and we can always refuse if their offer isn't adequate." The meeting took place the following Tuesday at Sarah's office. The HOA's attorney was a nervous-looking man named Robert Chen, who clearly wished he was anywhere else. He'd brought a representative from the management company, a middle-aged man named Dennis, who kept wiping sweat from his forehead despite the air conditioning. "My clients are prepared to offer a full dismissal of the lien and a waiver of all claimed fees," Robert began. "That's the bare minimum," Sarah replied coolly. "That's just putting my client back to where he should have been all along. What about the damages, the stress? The fact that he had to hire an attorney because your clients violated state law?" Dennis jumped in. "We've discovered that there was an error in our accounting system. When Meadowbrook switched to our management company 2 years ago, some automatic payment information didn't transfer correctly." "So you're admitting that the liens were placed in error?" "We're admitting there were technical difficulties that led to inaccurate records." I leaned forward. "Did you verify those records before threatening to foreclose on people's homes?" Dennis wouldn't meet my eyes. "We relied on the information provided by our system." "That's not an answer," Sarah said. "North Carolina law requires specific steps before placing a lien. 30-day notice, itemized statement, opportunity for a hearing. Were any of those steps followed?" The silence that followed was telling. Robert cleared his throat. "My clients are prepared to offer $5,000 in addition to lien removal and fee waiver. The statutory damages alone could be $15,000 or more," Sarah countered, "plus actual damages, plus attorney's fees. Your clients knowingly filed a wrongful lien without following required procedures. A judge isn't going to look kindly on that." The back and forth continued for another 40 minutes. Finally, they agreed to $20,000, removal of all liens, confirmation in writing that I'd never been delinquent, and payment of all my attorney's fees. Sarah also insisted on a clause requiring them to identify and remediate the situation for all other affected homeowners. It was a good offer, but something about accepting it felt wrong. These people had terrorized an entire neighborhood, threatened families with losing their homes, and now they just wanted to write a check and make it go away. "Can I think about it?" I asked Sarah after Robert and Dennis left. She studied me carefully. "You're entitled to, but Trevor, this is a solid settlement. If we go to court, there's always risk, even with a strong case like yours." "I know, but this isn't just about me. There are a dozen other families dealing with the same thing. If I settle, Brenda and her board learn nothing. They'll just be more careful next time. They're required to fix everyone else's situation as part of the settlement. Required by an agreement, sure, but who's going to enforce it? Another lawsuit," Sarah nodded slowly. "I see your point. If you want to proceed to trial, I'm with you. But I want to make sure you understand what that means. More time, more stress, more uncertainty." "I understand. Over the next few weeks, I became something of a reluctant neighborhood celebrity. Word had spread about my lawsuit, and people kept stopping me to ask questions, share their own stories, or just express support. Gary organized a group of the other affected homeowners, and they all decided to file their own complaints, using Sarah's lawsuit as a template. The HOA, meanwhile, was falling apart. 2 of the board members resigned, leaving only Brenda and one other person. The management company tried to distance themselves from the whole mess, releasing a statement blaming miscommunication and legacy system issues. My favorite part was watching the neighborhood Facebook group explode with drama. People were posting their payment records, comparing notes on interactions with Brenda, and sharing horror stories about previous HOA overreach. Someone dug up old minutes from board meetings, showing that Brenda had been pushing for more aggressive collection tactics for over a year. Discovery was a gold mine. Sarah's subpoenas uncovered emails between Brenda and the management company that were absolutely damning. In one email, Dennis had explicitly warned Brenda that they needed to send proper notice before filing liens, and Brenda had replied that they should just file them and sort it out later. In another, she'd complained about homeowners who think they can ignore HOA rules and needed to be made examples of. "This is bad faith on steroids," Sarah told me, barely containing her excitement. "With these emails, we're looking at punitive damages territory." The statutory damages are mandatory, but a judge might award additional compensation given how egregiously they violated the law. The case was set for trial in early May, about 4 months after I'd first received that threatening letter. In the weeks leading up to it, the HOA's attorney made 3 more settlement attempts, each with increasingly desperate offers. The final one was for $45,000 plus all the other terms we'd originally discussed. "It's your call," Sarah said, "but I think we can do better at trial." Let's go to trial. The courtroom wasn't anything like TV had led me to expect. It was smaller, less dramatic, with fluorescent lights and worn carpet. Judge Patricia Donovan presided, a no-nonsense woman in her 60s who'd been on the bench for over 20 years according to Sarah's research. The trial lasted 2 days. Sarah methodically walked through every piece of evidence. My bank statements showing consistent payments, the complete absence of any prior notice before the lien filing, the HOA's own governing documents outlining required procedures, and those beautiful, incriminating emails. When Brenda took the stand, I watched her carefully. She was trying to project confidence, but I could see the cracks. Sarah cross-examined her mercilessly. "Mrs. Carmichael, you received an email from Dennis Warren at the management company advising that proper notice needed to be sent before filing liens, correct?" "I don't recall that specific email. Let me refresh your memory." Sarah pulled up the email on the courtroom screen. "This is dated January 15th. Mr. Warren states, and I quote, 'We need to follow the statutory notice requirements before proceeding with liens. This is not optional. You see that?" Brenda's jaw tightened. "Yes." "And what was your response?" "I would have to review the email chain." "Allow me. You replied, 'Just file them and sort it out later.' That's what you wrote, isn't it?" "I may have been referring to something else." "What else could you have been referring to, Mrs. Carmichael? This entire email thread is about lien filings." Brenda had no good answer. She tried to claim she'd been overwhelmed, that the HOA was understaffed, that she'd relied on the management company's expertise. None of it held up under scrutiny. Dennis didn't fare much better. He admitted that his company had processed the lien filings without verifying that proper notice had been sent, relying on Brenda's assurances that everything had been handled. When Sarah pointed out that this was literally his company's job, he had no response. The HOA's attorney tried to argue that this was all just an unfortunate mistake, that there was no malicious intent, and that the situation had been remedied as soon as the error was discovered. Sarah countered with the timeline, showing that the remediation only happened after lawsuits were filed, and that the HOA had initially doubled down on their collection attempts even when presented with evidence of payment. Judge Donovan listened to everything with an unreadable expression, taking notes and occasionally asking clarifying questions. When both sides rested, she announced she'd issue a written decision within 2 weeks. Those 2 weeks were agonizing. I tried to focus on work, on normal life, but my mind kept drifting back to the trial. Had we done enough? Had I made the right call rejecting the settlement? What if the judge decided the statutory damages didn't apply, or that the HOA's actions, while wrong, didn't merit significant penalties? Gary invited me over for dinner one evening, and I found myself surrounded by several of the other homeowners who'd filed complaints. Their cases had been stayed pending the outcome of mine, which meant my trial would set precedent for how their situations were handled. "No pressure," joked Maria Martinez, one of the affected homeowners. "Just all of our futures riding on your case." "Thanks, that makes me feel much better," I replied, but I was smiling. The truth was, having their support meant everything. This had started as my problem, my fight, but it had become something bigger. It was about holding accountable the people who were supposed to serve the community, but had instead terrorized it. The decision came down on a Friday afternoon. Sarah called me at work, and I immediately knew from her voice that it was good news. We won. Big. I left my cubicle and found an empty conference room. "How big?" Judge Donovan awarded full statutory damages under North Carolina General Statute 47F. That's $15,000. Then she added another $20,000 in compensatory damages for emotional distress and reputational harm, plus full attorney's fees and costs. And here's the best part. She's ordered the HOA to conduct a comprehensive audit of all payments for the past 3 years and remediate any other wrongful liens within 60 days, with oversight by a court-appointed monitor. I sank into a conference room chair, overwhelmed. $35,000, plus fees and costs, yeah. And Trevor, the language in her order is scathing. She explicitly found that the HOA acted in bad faith, that they knowingly violated statutory requirements, and that their actions were particularly egregious given the severe consequences of wrongful lien filings on homeowners. This is going to make the other cases much easier to win. I don't remember much of the rest of that workday. I was floating, riding a wave of vindication and relief that felt almost unreal. When I got home, I found Gary and about 15 other neighbors waiting in my driveway with a case of beer and a banner that read, "Congratulations, Trevor." We had an impromptu party that evening, right there in my front yard. People I'd never spoken to before came by to shake my hand and thank me. Parents brought their kids, and we ended up grilling hot dogs and hamburgers as the sun set. It was the kind of neighborhood gathering that HOAs supposedly existed to foster, but which had been impossible under Brenda's regime of fear and arbitrary enforcement. The aftermath moved quickly. The court-appointed monitor, a retired accountant named Hugh, discovered that the technical glitch Dennis had blamed was actually systematic negligence. The management company had been cutting corners on record-keeping for years, and Meadowbrook wasn't the only HOA affected. Within a month, they were facing a class action lawsuit from multiple communities. Brenda Carmichael resigned from the HOA board 2 days after the judgment was entered. She sent a terse email to all homeowners stating she was stepping down to focus on personal matters. No apology, no acknowledgement of wrongdoing. The remaining board member, a quiet guy named Phil who'd mostly just gone along with whatever Brenda wanted, also resigned. Emergency elections were held in July. Gary ran for board president and won in a landslide. Maria Martinez became treasurer, and 3 other reasonable, community-minded people filled out the rest of the board. Their first act was to terminate the contract with Dennis's management company and hire a new one with actual competence and oversight. The other affected homeowners all settled their cases based on Judge Donovan's ruling. Most received between $10,000 and $20,000, depending on their specific circumstances and how long the wrongful liens had been in place. The HOA's insurance company ended up paying most of it, but the HOA itself had to come up with a significant chunk, which meant a special assessment for all homeowners. Ironically, I ended up paying about $300 as my share of that assessment. I considered it money well spent. The payment from the HOA arrived in August, a check for $35,000 plus another $12,000 for attorney's fees. Holding that check felt surreal, tangible proof that standing up to bullies and bureaucratic overreach actually could work. I used some of the money to take a vacation, my first real one in years. I spent 2 weeks hiking through national parks out west, deliberately choosing places with no HOAs, no neighborhood associations, no Brenda Carmichaels trying to tell people what color they could paint their mailboxes. The rest went into savings and some home improvements I'd been putting off. When I returned, the neighborhood felt different, better. The new HOA board had implemented actual transparency measures, including monthly financial reports posted online, open board meetings with real opportunities for homeowner input, and a clearly defined process for addressing violations that included warnings and opportunities to remedy issues before any penalties were imposed. Gary told me they'd also amended the governing documents to include stronger protections for homeowners, requiring even more stringent notice requirements than state law mandated. "We want to make sure this never happens again," he explained over coffee one Saturday morning. What Brenda did was criminal, even if she didn't actually get charged with anything. That was one of my few regrets about the whole situation. Despite the clear evidence of bad faith and the systematic nature of the wrongful liens, no criminal charges were ever filed. Sarah had explained that wrongful lien filings typically remained civil matters unless there was clear evidence of fraud or intent to permanently deprive someone of property. Brenda's actions, while reprehensible, apparently didn't quite cross that line. Still, there were consequences. Word spread through the local real estate community about what had happened at Meadowbrook Estates. Brenda's name became mud among real estate agents and HOA management circles. I heard through the grapevine that she tried to get on the board of another HOA across town and was rejected as soon as someone Googled her name and found articles about our case. Dennis's management company didn't fare much better. The class action lawsuit expanded to include over 30 HOAs across North Carolina and Southern Virginia. Eventually, they declared bankruptcy, and Dennis personally settled with several of the affected communities. His career in HOA management was effectively over. As fall arrived and the leaves started turning, I found myself reflecting on the whole experience. 7 months earlier, I'd been a guy who just wanted to live his life, pay his bills, and not cause trouble. The idea of suing anyone, let alone my own HOA, would have seemed crazy. But sometimes you don't get to choose your battles. Sometimes they choose you. The lawsuit had cost me time, energy, and no small amount of stress. There were nights I'd laid awake wondering if I was doing the right thing, if I should have just accepted one of the settlement offers and moved on. But every time I drove through the neighborhood now and saw people actually talking to each other, saw kids playing in yards without fear that the HOA would cite their parents for some arbitrary violation, I knew it had been worth it. I also knew I'd been lucky. Lucky to have documentation of all my payments. Lucky to find a good attorney. Lucky that North Carolina had strong statutory protections for homeowners. Lucky that Judge Donovan had been willing to hold the HOA accountable. Not everyone in similar situations would have those advantages. That's why I started speaking at local community meetings and homeowner forums, sharing my story and encouraging people to know their rights. Sarah connected me with a few other real estate attorneys who handled HOA disputes, and we put together a free guide for North Carolina homeowners explaining their rights and the proper procedures HOAs were required to follow. The guide got picked up by several local news outlets and spread through social media. I started getting emails from people across the state dealing with their own HOA nightmares. I couldn't help all of them, but I tried to point them in the right direction, share resources, and offer encouragement. One particularly satisfying email came from a woman in Charlotte who'd been facing a similar wrongful lien situation. She'd used our guide to challenge her HOA, cited my case in her complaint, and ended up settling for $22,000. "Thank you for fighting," she wrote. "Your case gave me the courage to fight mine." That email meant more to me than the money ever could. December brought the annual HOA Christmas party, the first one I'd actually wanted to attend in years. The new board had organized it as a genuine community celebration, rather than the stuffy, awkward affairs Brenda used to preside over like a queen holding court. I brought a date, actually, a woman named Felicia Edwards I'd met through a hiking group. She'd heard the whole HOA saga and found it simultaneously horrifying and hilarious. "You sued your HOA and won $35,000. She'd said when I first told her. "That's the most aggressively reasonable thing I've ever heard." The party was held at the clubhouse, decorated with lights and garland, with actual good food instead of the sad veggie trays and store-bought cookies from previous years. Gary gave a short speech thanking everyone for their participation in turning the community around, and people actually applauded. At one point, Maria pulled me aside. "I know you probably don't want to hear this, but we'd love to have you consider joining the board. We've got an open seat, and after everything you did, you'd be perfect." I laughed and shook my head. "I appreciate it, but I think I've had enough HOA drama for one lifetime. You guys are doing great without me. Fair enough, but the offer stands if you change your mind." As the party wound down and Felicia and I walked back to my house through the quiet neighborhood streets, I felt something I hadn't felt in a long time. Genuine contentment. Not just satisfaction with how things had turned out, but actual peace. "You're smiling," Felicia observed. "What are you thinking about?" "Just that this feels like home again. For a while there, I was seriously considering selling the place and moving somewhere without an HOA. But this is what it should have been all along. Good neighborhoods shouldn't require lawsuits to function properly." No, they shouldn't. But sometimes it takes one person willing to stand up and say enough is enough. I'm just glad I had the resources and support to actually fight back. We reached my driveway and I looked up at my house, the house that almost got foreclosed on because of a petty tyrant and incompetent management. The porch light was on, warm and welcoming, and inside was everything I'd built for myself over the past few years. The Lien was gone. The threat was gone. Brenda Carmichael was gone. And I was still here in my home, in my community, with $35,000 in the bank and the satisfaction of knowing I'd made things better not just for myself but for everyone around me. The legal battle might have been over, but its effects would ripple through Meadowbrook Estates for years to come. Future boards would operate under the shadow of what happened, with constant reminders that homeowners had rights and wouldn't hesitate to enforce them. The new transparency measures, the amended governing documents, the culture of actual community rather than authoritarian control, those were my real victory. As winter settled in and the year drew to a close, I found myself looking forward rather than back. Felicia and I were getting serious. Work was going well. The neighborhood was thriving, and every time I made my $65 HOA payment, watching it leave my account with a properly documented record, I smiled at the irony of it all. I'd fought the HOA and won. Not just in court, but in creating the kind of community that HOAs were supposedly designed to foster in the first place. And that, more than any financial settlement, was worth celebrating. The story could have ended there, with a neat bow and everyone living happily ever after. But life rarely works that cleanly, and there was one final chapter to this saga that I didn't see coming. It started with a phone call in February from a reporter at the Raleigh News and Observer. They were doing a feature story on HOA overreach in North Carolina and wanted to interview me about my case. I agreed, figuring it might help other people in similar situations. The article ran in March and went viral, not just locally, but nationally. Suddenly, I was getting calls from news outlets across the country, from homeowner advocacy groups, even from a producer for a daytime talk show who wanted me to appear alongside other people who'd fought their HOAs. I declined most of the attention, did a few select interviews with outlets I respected, and mostly tried to keep living my normal life. But the increased visibility had an unexpected consequence. It prompted a formal investigation into the practices of HOA management companies across North Carolina. The state attorney general's office launched a probe, and Sarah got pulled in as an expert witness. The investigation uncovered systematic problems across dozens of companies, not just Dennis's outfit. Inadequate record keeping, failure to follow statutory requirements, aggressive collection tactics that violated homeowner rights. It was endemic to the industry. By June, the state had implemented new regulations requiring HOA management companies to maintain specific certification, undergo regular audits, and follow strict protocols for collections and lien filings. Violations would result in fines and potential license revocation. "You started something," Sarah told me over lunch one afternoon. "One lawsuit turned into industry-wide reform. That doesn't happen often. I just wanted my house to not get foreclosed on. Yeah, and Rosa Parks just wanted to sit down on the bus." Sometimes the small acts of resistance are the ones that change things. I wasn't comfortable with being compared to civil rights heroes, but I understood her point. Standing up to injustice, even on a small scale, even in something as mundane as HOA disputes, mattered. It rippled outward in ways you couldn't always predict or control. The final piece of closure came in September, almost exactly a year after I'd first received that threatening letter. I got a certified letter in the mail, and for a brief moment, my heart rate spiked with old anxiety. Then I saw it was from Judge Donovan's office. Inside was a formal notice that the court-appointed monitor had completed his audit of Meadowbrook Estates HOA and found full compliance with the remediation order. All wrongful liens had been removed, all affected homeowners had been compensated, and new procedures had been implemented to prevent future violations. There was also a handwritten note from Hugh, the monitor. "Thank you for bringing this matter to light. In 40 years of accounting, I've rarely seen such blatant disregard for proper procedures. Your lawsuit undoubtedly prevented this from happening to many more families. Well done. I folded the note carefully and put it in a drawer with my copy of the final judgment and other documents from the case. Someday, maybe, I'd tell my kids about this if I had kids. About the time their dad sued the HOA and won, and about why it mattered to stand up for what's right even when it's difficult and scary. For now, though, I was content to just enjoy the peace. Felicia had moved in over the summer, and we were talking about getting engaged. The neighborhood was thriving under Gary's leadership. My automatic HOA payment went through every month without incident. And every time I pulled into my driveway and saw my house, my home, the place I'd fought to keep and won, I remembered that justice, when you work for it and fight for it and refuse to back down, is actually possible. The HOA threatened a lien without notice, violated state law, and tried to bully me into submission. But they learned the hard way that homeowners have rights, that those rights are protected by law, and that violating them comes with real consequences. $35,000 in statutory and compensatory damages, complete removal of all wrongful liens, attorney's fees paid in full, court-ordered remediation and oversight, industry-wide regulatory reform. Not a bad outcome for one guy with bank statements and the audacity to fight back. As autumn returned and the anniversary of that first threatening letter approached, I raised a glass to myself, to Sarah, to Gary and Maria and all the neighbors who'd supported me, and to Judge Donovan for holding the powerful accountable. The American dream includes homeownership, but it also includes justice. Sometimes you have to fight for both. And sometimes, if you're lucky and persistent and right, you actually win. That's my story. The story of how I sued my HOA for threatening a wrongful lien without proper notice, how they had to pay statutory damages under North Carolina law, and how one lawsuit turned into meaningful change for an entire community and beyond. Would I do it again? In a heartbeat. Because some battles are worth fighting, not just for yourself, but for everyone who comes after you. And that, ultimately, is what makes a house a home and a collection of houses a real community.